afternoon to everybody. It's a pleasure for me to be here and to participate in the conservation symposium for the first time. I would like to thank very much the organizers for the invitation, and I also would like to thank in particular the scientific committee chairs for their flexibility in order to allow me to make a live presentation. So my topic is entitled How International Lawyers Interact with Science. Allow me to start with one point which might be very surprising. And as surprising as it is actually science. It is actually science that is at the origin of the first rules and principles regarding conservation and environmental protection at the international law. So science has been the triggering factor for the first rules and principles regarding conservation and environmental protection at the international level. I would like to in particular emphasize how science has been a factor, a vector for the formulation of the first international conservation measures in the history. And also I would like to emphasize how science has been behind the formulation of one of the most important principles of international environmental law, which is what we call the no harm rule. Let me start with conservation measures. The first conservation measures at the international level were formulated in 1893. In 1893, in the context of an arbitration, between the United States of America and the United Kingdom, an arbitration that is called the Bering Full Seals arbitration. How did that arbitration happen? Well, basically, at the end of the 19th century, the United States of America was seizing Canadian vessels which were engaged in sealing, so in the hunting of full seals in the Bering Sea, and would also put in jail the crew of those Canadian vessels because they were engaged in sealing. And the US at that time believed that it had a right of property over those full seals that would from time to time cross US territorial waters. And because the US believed at that time that it had a right of property over those full seals, it's also believed that it had a right of extraterritorial protection of those full seals. So this is how the dispute arose between the United Kingdom and the US. I'm saying the United Kingdom because at that time Canada was still under British dominion. So the UK was in charge of the international relations of Canada. So when the US proceeded with the seizure of those Canadian vessels and the imprisonment of the crew, this triggered a dispute between the two countries, and they decided to submit the dispute to an arbitral tribunal composed of international lawyers that would have to decide whether the US had the right to take such measures of protections regarding the full seals. What is interesting for us is that at the end of the 19th century, there was actually not yet at the international level a body of law that would protect natural resources. There was not yet a body of law that would protect the environment or that would protect certain species from the fauna or the flora. So the position of the US, the argument before the tribunal, the US argument before the tribunal was to tell the tribunal, well, be creative, create law. You need to fill the vacuum in the legal system. So create rules that would allow to protect the full seals. The position of the United Kingdom at that time was to say that the tribunal had to be prudent and had only to apply what we call customary law, so what was accepted as being the law by the nations at that time. And the position of the United Kingdom was to actually advance that back in the days, in the 19th century, the only rule that was existing in customary law was the freedom of nations to kill wild animals, no? The freedom of nations to kill wild animals, so that the tribunal would have to be deferential to that rule and allow, citizens of different nations to continue hunting seals. What is interesting is that the tribunal actually decided, and that was why I'm saying this was the first conservation measures ever formulated at the international level. The tribunal decided to actually enact rules that would protect the seals. Also, if you check the decision of the tribunal in the Bering Full Seals arbitration, you would see that the tribunal basically acted as a legislator and formulated Article 1, Article 2, Article 3, that were basically rules that would allow to protect those full seals and that would allow them to reproduce during a certain period of time, and that would also protect them from certain weapons when citizens of certain nations would be engaged in sealing. But those conservation measures that the tribunal enacted were actually prompted by scientific experts that the tribunal consulted. The tribunal consulted scientific experts to ask them, what would be the proper way to protect those full seals despite the legal vacuum. And so it is scientific experts that have actually inspired the tribunal to enact those conservation measures that were, as I said, the first conservation measures ever adopted at the international level. But science did not only trigger the first conservation measures at the international level, it also triggered the formulation of very important principles, very important legal principles of environmental protection, like the no harm rule. I don't know if everybody here is familiar with the no harm rule, but the no harm rule is what I would call the backbone of international environmental law. The no harm rule means that basically a state has to ensure that activities on its territory do not cause damage to the environment of other states. That states have to make sure that their territory is not used or allowed to be used in such a manner as to cause injury or damage to the environment of other states. And once again, as surprising as it is, this no harm rule was actually a result of a scientific concern or of a scientific element. The no harm rule was formulated in 1941 in the context of another arbitration called the Trail Smelter arbitration. The Trail Smelter arbitration was a dispute between the United States of America and Canada this time. It's a dispute that arose because of emissions of sulfur dioxide that were coming from British Columbia and that were harming the crops and the cattle in the state of Washington in the United States of America. So because of the injuries that US farmers suffered because of the emissions coming from a plant at the border of British Columbia, the border between British Columbia and the US government complained to the Canadian government and asked for some reparation for the damages that US farmers have suffered because of those emissions of sulfur dioxide. So Canada accepted its responsibility back in the days, but the two countries disagreed on the proper amount of reparation, and that's why of compensation, and that's why they decided to submit the dispute to an arbitral tribunal. But what is interesting is that arbitral tribunal in the Trail Smelter arbitration took opportunity of that case to actually formulate that no harm rule, to tell nations that under international law, every nation, every state has the duty to make sure that its territory is not used in such a manner as to cause damage to the environment of other nations. But when you pay attention to the reasoning of the tribunal in the Trail Smelter arbitration, it is interesting that to see that it is actually science that has prompted the tribunal to formulate such a rule, because what the tribunal said is that such a rule actually would apply when a state has clear and convincing scientific evidence. So basically, the tribunal explained that when a state has clear and convincing scientific evidence that the activities on its territory might harm as a state or the property or the persons on the territory of other states, then states have to make sure that that they prevent such activities to be carried out. So the no harm rule has been at least at its birth, at its inception, connected to the very idea that, you know, when states have science, they need to make sure that they act in a certain way not to harm the environment of other states. So it's very interesting to see that science, at least at the early stage of the development of international environmental law or the international law regarding conservation of the nature, has been very decisive, very influential in the formulation of rules and principles. And it is maybe that that early influence that explains why international lawyers have been always very deferential, actually, to science when it comes to environmental protection. This is what I call the perverse effect of this early influence of science in the making of international environmental law, is that it has led to a very deferential approach to science in the field of international environmental law. And that deferential approach, or that deferential perspective to science, was clearly reflected in 1972. 1972 is the year of birth of international environmental law. It is in 1972, the United Nations convened in Stockholm, in Sweden, the very first United Nations conference ever dedicated to environmental protection. It was called the Stockholm Conference on the Human Environment. It is usually considered as the birth of the international law relating to environmental protection. And it's interesting to see that in Stockholm, when you pay attention to the declaration of principles that were adopted there, that there was actually a huge emphasis on science. There was actually this very deferential approach to science as the tool for environmental protection. I would like just to read for you Principle 18 of the 1972 Stockholm Declaration, because I believe it's very revealing of this spirit. Principle 18 reads as follows: science must be applied to the identification, avoidance, and control of environmental risks. Science must be applied to the identification, avoidance, and control of environmental risks and the solution of environmental problems, and for the common good of mankind. When you pay attention to the language here, you can see that there was actually a strong belief at the time of the birth of international environmental law. There was a strong belief within the international community that science would actually allow us to predict environmental complexity, that science would allow us to deal with environmental complexity, that science would allow us to even avoid environmental risk. So this Principle 18 of the Stockholm Declaration is very revealing of what I call the deference towards science within international law. Then there has been at a point a turning point. At a certain point in the development of international environmental law, there has been a turning point. The turning point for me is 1985. 1985 was the year of the adoption of the Vienna Convention on the Protection of the Ozone Layer. And the Vienna Convention on the Protection of the Ozone Layer was actually a little step forward to bring a bit of the scientific uncertainty rationale in the making of international environmental law. If you pay attention to the preamble of the Vienna Convention on the Protection of Ozone Layer of 1985, you will see that one of the paragraphs says, mindful of the precautionary measures for the protection of the ozone layer which have been taken at the national and international level. Mindful of the precautionary measures. It was the first time at the universal level that we had an international treaty actually mentioning the need for precautionary measures, the importance of precautionary measures. And whenever we talk about precautionary measures when it comes to conservation or environmental protection, the idea is, taking into account scientific uncertainty. So the Vienna Convention was a turning point, not a radical one, because you see that the Vienna Convention just mentioned the fact that it was mindful that states have adopted precautionary measures at the national and international level, but it was not a radical step, but it was a turning point towards better integration of scientific uncertainty, toward a better acceptance of the need to take into account scientific uncertainty in the conservation of nature. The paradigm shift at the international level occurred in 1992. In 1992, there were two important steps towards a better integration, at least in the international legal discourse, a better integration of scientific uncertainty in the international legal discourse. The first step was the conclusion of the United Nations Framework Convention on Climate Change. The United Nations Framework Convention on Climate Change of 1992 was actually an instrument concluded in a context of scientific uncertainty. It was the first time ever in the history of international law that a treaty was concluded in a context of, I would say, almost total scientific uncertainty. If we remember well, in 1990, when the Intergovernmental Panel on Climate Change, the IPCC, issued its first report, its first scientific assessment report ever, the message, the position of the IPCC was to say that, climate change, global warming was characterized by scientific uncertainty. Uncertainty regarding its existence, its reality, uncertainty regarding its impacts, uncertainty regarding its effects, etc. Despite this scientific uncertainty, the international community decided to conclude the United Nations Framework Convention on Climate Change and decided to launch cooperation in order to deal with the protection of the global global climate system. So this is a very interesting example of why I'm talking about a paradigm shift starting from 1992. But also in 1992, we had the Rio Conference. We had the Rio Conference on Environment and Development. The Rio Conference on Environment and Development launched the Sustainable Development Agenda. And in Rio, a declaration of principles was adopted. Maybe one of the most famous declaration of principles when it comes to the international law regarding environmental protection. And in Rio, for the first time, the international community formulated at the international level what we call the precautionary principle or the precautionary approach. What is the precautionary principle? And it is principle 15 of the Rio Declaration. The precautionary principle means that scientific uncertainty should not be used as a pretext, not to adopt effective and proper measures of environmental protection. That states should not hide behind scientific uncertainty, not to take proactive measures to conserve the nature. So this formulation at the universal level of a principle that would deal with scientific uncertainty was a very important step that actually contrasts with the radical deference to science that has been prevailing since the end of the 19th century till the 1980s. So we see that there has been a paradigm shift in the international legal discourse. However, despite this paradigm shift in the international legal discourse, what we have witnessed is basically the inability of international lawyers in practice to really integrate scientific uncertainty when it comes to environmental protection. So yes, the legal discourse has shifted, but in practice, international lawyers have been very inefficient in truly integrating scientific uncertainty in the management of the nature. Let me just give you one very recent example of another case before the International Court of Justice this time. the famous pulp mills case which was a dispute between Argentina and Uruguay. Argentina complained before the International Court of Justice that Uruguay authorized the operation of pulp mills on the river Uruguay that Argentina are sharing. And the main reason for Argentina's opposition to the Uruguay's project was that these pulp mills that are known for being very polluting technologies would actually destroy the ecosystems of the Uruguay River, would actually destroy the quality, affect the quality of the waters, would also affect the quality of the air, would contribute to climate change. So this was the reason why Argentina filed that case, basically against Uruguay. But at the end of the day, Uruguay won the case, despite all the real and important environmental risks that were at stake. The International Court of Justice decided that Uruguay could proceed with its pulp mills. Why? Simply because, according to the International Court of Justice, Argentina did not put on the table conclusive scientific evidence. I'm quoting what the court said itself, that there was no conclusive scientific evidence. So if you are not able to bring conclusive scientific evidence, then you cannot oppose to the hazardous activities of another state, which we know doesn't. We know clearly that this doesn't make sense. Environmental complexity, the environmental risks are characterized by scientific uncertainty. So you cannot treat environmental problems from the usual typical approach to science, which is bring scientific evidence to substantiate your claims. Quite often, environmental impacts or damages, they would occur or arise later on. It's not right now. It's not in a short-term perspective that you would see those environmental damages. So it's very hard to ask a state to bring conclusive evidence that damages would occur. So this is how Uruguay actually won the pulp mills case, because Argentina was not able to bring conclusive scientific evidence. Now, we all know that the river Uruguay is totally dark, polluted because of the pulp mills. Now it is clear that the pulp mills were dangerous for the ecological balance of the Uruguay River. But you see that those lawyers, those international lawyers that are sitting in international courts, they were not able to integrate that actually environmental protection will require to take into account scientific uncertainty and not just hide behind scientific certainty. So what does it teach us? I see that I have 4 to 5 minutes remaining. What does it teach us in terms of interaction? Because my topic is how international lawyers interact with science. So when you look at the interaction between international lawyers and science today, for me, I think that we can summarize it in light of what I call 3 dogmas. There are 3 dogmas that are actually guiding international lawyers when they're dealing with science. The first dogma is what I would describe as follows: science can always be known. International lawyers believe that science can always be known, or science should always be known. And of course, what does it mean? It means that there is a reluctance to even integrate the idea of scientific uncertainty in the practice of international law, and in particular in the protection of the environment. One very good example of this reluctance actually to even use the vocabulary or the expression scientific uncertainty is the World Trade Organization, the WTO. If you go and look into WTO law, you will see that in the WTO, they call scientific uncertainty, insufficient scientific evidence. So there is scientific evidence, but it is insufficient. It's not scientific uncertainty. It's just insufficient scientific evidence. So this is the first dogma. Science can always be known. The first dogma that is actually guiding international lawyers in their interaction with science is that they believe that science can always be proven. science can be proven. So international lawyers were never able actually to get rid of the traditional approach to evidence, of the traditional approach to the burden of proof. As I have shown you a bit with the Pulp Mills case, there is still this idea that you should be able to use science. You should be able to prove the environmental risk you are claiming might happen, or the environmental harm you are claiming might happen. This is another dogma, I would say, of the interaction. And last but not least, the third dogma that is guiding international lawyers when dealing with science is that they believe that science can always be managed, that lawyers can manage science. Lawyers can actually understand science. One very good example I would like to give very briefly is the dispute, the famous case before the International Court of Justice called whaling in Antarctica, Australia versus Japan. You know that for many decades, Japan was actually killing hundreds and hundreds of whales, claiming that they were killing whales to understand the biology of whales, that they were doing it in the name of scientific research. At a certain point, Australia was fed up with the so-called Japanese scientific research program on whales, and Australia complained that actually the so-called Japanese scientific program was in violation of the 1946 Whaling Convention. There is a convention called the 1946 Whaling Convention that has as an objective the protection, the conservation of whales. And the Whaling Convention, Article 8 of the 1946 Whaling Convention says that whaling is prohibited except when states are doing it for the purposes of scientific research. Only when they're doing it for the purposes of scientific research. So it means states could engage into whaling if it is for the purposes of scientific research. So in that dispute, Australia and Japan disagreed on what is scientific research, what is the meaning of scientific research. They also disagreed on what is scientific. But the position of the International Court of Justice, again, international lawyers, was to say, well, we don't need to understand what is science. We don't need to know what is science. We don't need to know what is scientific. We don't need that. We can actually just figure out, whether what Japan was doing could reasonably look as science, but without understanding or knowing what is the definition of science. And then the International Court of Justice itself, formulated criteria to say, well, science is, for instance, when you publish articles. So if you are doing research and you don't publish articles, this is not scientific. So this is just to show you how international lawyers also believe that they can manage, that they can understand science. And there's something that was very important in the whaling case was, for instance, one question was whether you need to use lethal methods to understand the biology of whales. So you need scientists that explain to you, why lethal methods are relevant or not relevant to conduct scientific research on whales. The court said it didn't need all that. And this is for me what I call the dogma that lawyers can manage science. So all that in conclusion to say that when you look at the practice, what we can see is that international lawyers are actually not very well equipped. They are not actually very well equipped to deal with science. And this lack of integration of scientific uncertainty by international lawyers has been to a certain extent the cause of the lack of effectiveness of environmental protection at the international level. We all know that environmental governance is very weak, that environmental governance till today is global environmental governance is not that efficient. Well, one of the reasons is because international environmental law and international lawyers have still not been able to properly integrate scientific uncertainty in the conservation of nature. So I believe that in the future, we need to have an approach that would be maybe a bit more Popperian, that would actually allow to push lawyers to understand and to accept the idea that science might be falsifiable. So thank you very much for your attention, and I'm looking forward to any comments or questions that the colleagues might have. Thank you.
Thank you very much, Professor. That was very interesting and quite revealing and thought-provoking. Very interesting to see the evolution and the progressive role that science has played, but still quite a lot of need for acceptance of this principle of uncertainty. I have a few questions. We've got time for a few questions. I have one from Clinton Carbett, and it reads, Prof, thanks for an interesting talk. Water governance has always been a contentious issue between nations. How do you see Ethiopia's mega dam project that is damming the Nile River playing out with Egypt and Sudan downstream? It seems that politics will trump conservation and water needs in this case.
So the question is, what do I feel about the risks?
Oops. So, Prof, it's I'll read it again. I'm not sure why you can't see it. Water governance is a contentious issue. How do you see Ethiopia's mega dam project that is damming the Nile River playing out with Egypt and Sudan downstream? It seems that politics will trump conservation.
Yes, thank you. That's an excellent question. I cannot go into details regarding the Grand Ethiopian Renaissance Dam, of course, because to a certain extent I'm involved in the current negotiations that are taking place between Egypt, Ethiopia, and Sudan regarding the filling and the operation of that dam. But I think this is an excellent question when it comes to water governance. It's actually interesting to see that in many of the cases that have been brought before International Court of Justice, the management of water was at stake. And it's interesting to see Pearl Mills was an international river, but there is another case I did not mention from 1994, which was a dispute between Hungary and Slovakia over the Danube, where the two countries agreed in the 1970s to build a system of dam. And then later on, Hungary considered that this was going to destroy the ecosystems of the Danube, refused to build its part of the dam, and then this created a dispute. They brought the dispute before the International Court of Justice, and the position of the International Court of Justice was to say that it could not say, what was the best scientifically founded argument, because there was simply an impressive record of scientific evidence on the table, and the court felt that it could not deal with, what was the best scientific argument there. So it's very interesting to see that when you look at water disputes, till today, international courts and tribunals have not been able to integrate actually the complexity of water governance, the complexity of the management of transboundary water resources, and the scientific aspects of it. But I am among the people who believe that proper management of water resources has to be accompanied with, a good scientific management of those water resources. But a good scientific management doesn't mean just taking into account the scientific certainty. It means also taking into account scientific uncertainty. We know, for instance, that there's a lot of scientific uncertainty regarding groundwaters. We know that there's a lot of scientific uncertainty regarding aquifers. And quite often when states even negotiate or use transboundary water resources, they are just concerned with the evidence regarding surface waters. The rest is not fully taken into account. So international water law would require to take into account also scientific uncertainty. But to jump back on the question of our colleague, it's interesting to see that till today, there is not a strong rhetoric, there is not strong practice that integrates better those scientific aspects, those scientific dimensions in international water negotiations.
Thank you, Professor. Let's move on. I've got a question from Michelle Fab, who's actually on our South African scientific authority that deals with CITES issues. Please, Prof, would you give your opinion on how science plays out in CITES?
That's an excellent question. I'm not I think, Craig, you know better than me the practice of CITES, so I would not be the best person to answer the question. But I think it's interesting. It's very interesting to know that CITES was actually negotiated, was actually concluded in the 1970s. So in 1974, if my memory is good, the CITES Convention, and in 1973, and at that time, the dominant approach at the international level was that science would allow us to know everything about complex environmental phenomena. So CITES was surely not concluded at a time when the international community had integrated, at least in the legal rhetorics, the idea of scientific uncertainty. And that is maybe the problem. That is maybe the problem, is that CITES is dealing with, how do you call that, threatened species of fauna or flora that might extinguish. But the approach back in the days was very scientific certainty based. And what does it mean? It means that the approach was not enough anticipatory, in my view, because we would wait till we have clear scientific evidence that this species is going to disappear, this species is going to extinguish, to do something, to put that species in the list of Annex 1 or Annex A of CITES as a species that needs to be protected. But I think this is not enough, and we are seeing today, particularly in the context of the global health crisis, how certain animals would have needed more protection, actually, and how those species of the fauna are disappearing, and are, to a certain extent, even responsible of the spread of certain diseases. So I wouldn't say more about CITES because I don't follow it in details, but it's interesting to see that it is a treaty that has been concluded at a time when the international community believed that science should be the triggering vector for environmental protection, but scientific certainty, not scientific uncertainty.
Thank you, Prof, for that. Yeah, on the other flip side of the coin is that we've noticed that often science is ignored in favor of a feeling and people's, let's call them, for want of a better word, bunny huggers. So what happens is the science is there often to even downlist the species, and it gets ignored for one reason or the other. Certainly, if the science is there to make sure that a species is listed on one of the appendices, then so be it. But there are cases where they don't meet the criteria and actually shouldn't be there. I think there will be an interesting talk by Michelle herself later in the session that will look at white rhino specifically. I'm going to move on to the last question from Dr. Andrew Blackmore. He says, an excellent talk, Prof. Could it not be equally argued that scientists do not lawyers and particular international ones, and hence do not present their information in a usable form.
Thank you so much, Andy. I agree that is an excellent point. You know, I had as an idea to finish my speech with a call for what I would call a new scientific pact, between international lawyers and scientific experts. You know, I believe that at least when it comes to environmental protection, it is impossible. It is impossible to dissociate science from law, and it is also impossible to dissociate law from science. So what do we need? We need to think today at the international level. We need to think about mechanisms. We need to think about communicational bridges between scientific experts and law. And we need to think about how actually science can turn into policy, and how can policy, to jump back on what you were saying, Craig, would reflect better the science, may it be scientific, strong, sound scientific evidence, or uncertain scientific evidence. And we have models. We have models at the international level. We just need to maybe, strengthen those models. But the IPCC, the Intergovernmental Panel on Climate Change, is actually an institution, is actually a body that is trying to build that interface between science and policy. In the IPCC, you don't only have scientists, you have also policymakers, lawyers that are there. The IPBS, the Intergovernmental Panel on Biodiversity and Ecosystemic Services, is another model that is trying to better, build communicational bridges between scientists and lawyers. But we need to have much more of those models. We need to have much more of those mechanisms in the entire system of environmental governance. It should not just be limited to pockets. But we need also, and there I agree with you, Craig, we need also to have political will that is really reflecting the science. It is true that sometimes you have the science saying this is the way to go. Let's just think about climate change negotiations. The IPCC has been, ringing the bell, has been, ringing the alarm for the last 25 years. But when you look at the IPCC scientific assessment reports, how they are alarming, and you look at, what states are doing in terms of measures, in terms of treaties, legal instruments to reflect that science, there is a gap. There is a gap. So it's interesting to see that sometimes the science is also very clear, telling states this is what you need to do, and state would still act in such a way not to integrate it properly. So I agree that we need to strengthen that. And we need to build a culture of dialogue. Lawyers should try to better understand what is science when it comes to environmental protection, and scientists need also to better, integrate the legal dimensions, the legal hurdles when formulating actually scientific knowledge.
Thank you, Professor Mbenque. Thanks very much for your presentation.